how to avoid the four-headed monster. Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, pull up your chair, get your pen out and your notebook, because today subscriber sent a great question into the Elder Law Care Center here. Patrick, what is a letter of intent in special needs planning? I refer to this as letter of instruction. Letter of intent is another term for it, but letter of instruction to my trustee, letter of instruction to my executor, personal representative, letter of instruction to my backup helper quarterback in the event you have a special needs child. My recommendation, create that third-party supplemental needs trust when you're alive and well, because typically the other only fallback provision is creating a first-party special needs trust, which is typically not ideal. Why? Because first-party special needs trust requires government payback, where third-party supplemental needs trust does not require government payback. If there's any money left in that third-party supplemental needs trust, those funds can go to your other children, your other loved ones, your other beneficiaries, and not to government. Huge difference, huge benefit there, okay? When we create a third-party supplemental needs trust, it's often advisable to also create a letter of intent or letter of instruction to my trustee of that trust on what your vision is for your loved one, what your expectations are for your loved one. And you can utilize this also for minor children as well. But in this context here today, how can I use a letter of intent or letter of instruction to my trustee for my special needs loved one? After you protect and preserve that asset that you put into your third-party special needs trust, now you want to give written instructions. It's prudent and wise to give written instructions to your trustee. It's important to have these conversations with them as well, but very prudent and wise, practical, to put the instructions, your vision, your wishes, memorialize that, reduce that to a legal writing called letter of instruction to my trustee, letter of instruction, letter of intent to my trustee. Again, what your wishes are, what your expectations are, what should the money be utilized for, and so forth, how you would like to enhance their quality of life. You can put things in there like how long your special needs child is allowed to live in the property if you have a home and they currently reside in your home. Are they allowed to reside in your home, have that housing perpetually for life? Maybe so, but where are the funds going to come from to pay the carrying cost? Do you have a mortgage? Do you have a home equity line of credit? How are they going to pay that? How are they going to pay the real estate property taxes? How are they going to pay for the homeowner's insurance? How are they going to pay for the upkeep and maintenance of the property, repairs, improvements, etc.? Do you have enough funds allocated in your treasure chest to take care of the house for your special needs loved one? Do you have life insurance? Do you have qualified retirement accounts, IRA, 401k, and that money is properly earmarked and funded to the third-party supplemental needs trust, and the monies in there can be utilized to cover all those carrying costs that I just referenced to make sure that your loved one can live in your family home for as long as possible. That would be my recommendation. Reduce that to writing so your trustee knows not to sell the house right away, not to uproot your special needs loved one from their community, from their home, from their family home where they feel safest and secure, and maybe displace them in some type of group home environment. You probably do not want that. So strongly recommend reduce that, memorialize that in writing, because your trustee now has a fiduciary duty of loyalty under trust law to follow your instructions for the best benefit and in the best benefit of whom? The beneficiary, your special needs loved one. And if your trustee does not comply with your instructions and they violate that and they do not conform with your instructions and they have the ability to do so, they could be held personally liable. They would be considered violating their fiduciary duties, in breach of their fiduciary duties. But when you have that letter of intent or letter of instruction, you're going to make it crystal clear whether they breached or violated their fiduciary duties or not, okay? Really, really important to work with a qualified elder law attorney or special needs attorney to assist you create not just a third-party supplemental needs trust, but the cousin to that, which is what we're talking about here today, letter of intent to my trustee or letter of instruction to my trustee. Folks, hopefully you found this educational video helpful. Click the subscribe button, click that notification bell. Please share this video with other loved ones that you think could benefit from the video as well. And by all means, pick up a copy of my book on Amazon, Patrick Kelleher, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. Thank you, folks, for joining us today at elderlawcare.com.